Hi friends from around the world. We are on trade secrets, and you know now what are the conditions for trade secrets, right? It must be a commercially valuable information of what is the subject matter of the trade secret. It must kept secret, right? And it must be a secret not available to the public, and it must be protected by the owner of the trade secret. These are the three conditions, and it is more or less the same around the world, right? There's nothing very much national about it, although it is the national country which applies its own rules, its own jurisdictions, but they are more or less the same around the world. Now, on trade secrets, I wanted to give you more on examples, because that is a bit difficult to bring over to your business mentality. So it is better about some examples. So when I was traveling, I can't remember whether it was Egypt or was somewhere in the Middle East, I came across a shop with some herbs, special herbs, etc. And I was told this herb is a mixture of herbs, and this is owned by the whole generation of the shop owner and previous generations of his ancestors and so. And he said that's a proprietary formula of the herbs, and this is, well, more expensive than the other herbs, but it tastes very good for, I don't know, whatever dish it was. I can't remember, some time ago. Now, he charged me 400 times more for that proprietary formula of herbs than for a series of herbs, what would be the generic ones. So this is a trade secret. This is a trade secret. He monetized upon its trade secret. And, well, it was good. Whether it was 400% better than others or my own mixture, I don't know. But this is an example of a trade secret. But I wanted to tell you about the famous Listerine-Case. That is a case which is taught in universities in intellectual property and for trade secrets, and it is interesting in two matters for me. There is a business case and there is an IP case, trade secret case. So both are inside that case, and therefore I think it is very instructive to have it reviewed here. I will not go into legal technicalities. There's not necessary. So you, business owner, you will get it as we go on by the case. So there are the three parts, I would say. One is the background of the case. I will go into the background, and then the business case and the IP case at the end. So the background is in 1879, so some time ago, and it was in the US. But as I said, it is not really a country-wise jurisdiction here applicable with regard to trade secrets. So in the US, there was a doctor who made some, that was new for that time, surgical disinfectants. There was some alcohol, and then together with mixed with some essential oils, he came up with a good disinfectant, which killed all the bugs, all the parasites, whatever. So it was very effective. Now, he tried to sell it. He tried to monetize it as a trade secret, because it was not disclosed what was inside. And, he did not get any traction on it. It was very difficult to sell. He went to different dentists in order to see whether he could be something with, with mouth washing, etc. But no, it was not possible. And then in 1881, so still after 2 years, he made a contract with Mr. Lambert. Mr. Lambert was a kind of licensee of that trade secret, so licensee for the trade secret, that is a bit of special. And they made a contract. So a contract, here is the contract. It is very short. It is 127 words, as you can see. But it has a big impact. So it was just among them. There was no lawyer involved and so. So Mr. Lambert now tried again the same thing. He went to different dentists and he tried with other diseases to sell it to the public. But there was an obstacle there. It smelled very bad, like old shoes or petrol, etc. And people are not able to get it, and nobody wanted it to buy. And then it goes on and goes on. Now, in the contract, there was something about royalties, right? Fee, trade secret, the licensee, so to have a trade secret, they come with royalties. But there was no traction on the sale, so not much royalties have been paid. And well, Mr. Lambert died, and now Lambert Jr. Came in. That was around 1923, and Lambert Jr. He tried as well, and he failed, but still he got the feedback from the market. Well, it smells very bad, and that is not something people want. And he came up with a business idea, and this is now the business case. A business idea with regard to Listerine. Listerine, by the way, has been named after an initial inventor, so to say, an Englishman who tried to make this kind of surgical disinfectants, Mr. Lister. So, back to Mr. Lambert Jr. He wanted now to build up the business case of that. And what did he do? Well, he had some money left, and he made a big advertising campaign. And what was the background of this campaign? Well, he wanted to sell a medicine. So with this, Listerine was a medical approach. And a medical approach needs what? Yes, needs a disease, right? So he invented the disease. He said in the advertising, you have halitosis. Halitosis, I think it was named. You have halitosis, and the people behind your back, they are talking about you, about your bad smell, and your closest friends wouldn't tell you because they are embarrassed about your bad mouth smell, etc. So on this advertising campaign, what people would expect is a medicine, right? And a medicine does not taste good. Medicine taste, it must be whatever the taste of the medicine is, anything less than good. Anything different than good, right? So that get traction on the market, and the business went better. And also, well, the initial contract, the royalties have been paid. So this went on. In 1931, a different development entered into the space, which was the reverse engineering. So it was reverse engineered. You know already that trade secrets can be reverse engineered if it can, and then afterwards it is open. There's no infringement if it is done on reverse engineering. So it is open in the market. You cannot do anything about it. Therefore, the keeping secret is so important, right? Now, it was reverse engineered and in the open, but still, Listerine by 1931 had already penetrated the market, and people knew about it. So there was no problem with any other product on the market which tasted similar. because people want to have the Listerine, the trademark Listerine that had been built, the trust between the company and through the trademark had been built up. But in 1955, so the heirs, I don't know, there was Lambert Jr., the grandson already or whatever, they came about, well, that's enough. That is now 70 years into the acquirement, the acquisition of the formula, but the formula was not even secret anymore, and we paid, I don't know, 22 million, I think 22 million of dollars of royalty fees to the original doctor or the heirs of the doctor, and the 1.6 million a year, that was at 1955 the case, for something which was not even secret anymore because it has been reverse engineered. So they went to the court. And the court looked at, and this is the case here of the court, and the court looked up the contract, the initial contract I showed you before. And that contract, they said, well, it is nothing about the secrecy here. It is a formula which has been sold. It was secret by the time, but the legal matter, it did not depend on the secrecy of the trade secret. So whether it is reverse engineered or not, it is not the matter of the contract. And moreover, the condition of the royalties and of the marketing and of the secrecy that lied more with the licensee than with the licensor. So also the risk. And the court ruled that you have to carry on with regard to the payment of royalties for Listerine, although it had passed already some 70 years. Now, this is the Listerine-Case. It seems to me quite interesting, and there are some lessons around it. And I would like to wrap it up here. What are the lessons to be drawn of that case? Well, the first case is a contract matters. A contract with regard to the licensee, if there is a licensee, if it is your own marketing and your own business, you are marketing your trade secret formula or whatever it is, the process, it is you. But here we have a contract, and the contract matters. And even a short contract of some, that is 127 words, they can last very long, but the contract matters. And then you have a combination of trade secrets and trademarks here. Trade secrets, meanwhile it is secret, is an asset of yours. When it is not anymore secret, it is not anymore an asset of yours. Makes sense, right? But then you have a head start with regard to the competition, because you, meanwhile, it was secret, you had the monopoly, you can build up trust with your trademark. And once it becomes in the open, the trade secret is not anymore a trade secret, then you have the trademark to build on and go on with your sales. And this is the case here. So it has become a public matter, the formula, but the business of the trademark and the people trusted in Listerine so much that they continue to buy the Listerine, and that is still valid today. So you can monetize trade secrets. That would be another lesson for me. Monetizing trade secret. Trade secret must be kept secret, and kept secret through contract, licensee, that comes a bit out of your mind, but still it is possible. if the other party, they kept the secret, and the licensee has probably all interest to keep the secret because that is the asset is acquired, and he or she has to pay license fees with regard to their sales figures. So thank you for being here with me, and have a nice day.